Well, you are watching Day 5 of After the Trial. This is a special streaming show we have here on WFAA+. We have special coverage of this track meet stabbing trial. Carmelo-Anthony is charged with murder and the death of Austin Metcalf. Again, this is special coverage, and we have breaking news today. The state has rested its case. We have an awesome panel here. We have Kevin Harris, longtime attorney. You do defense work. You've been on the state side as well.
Yes, sir.
Right? We have Rebecca Lopez, senior crime and justice reporter. I feel like we should be doing this every day now because we have been. I mean, we have been, but we should be doing this for other stuff too. Cause,
absolutely.
Your expertise is incredibly valuable.
Thank you.
Okay, let's start here. Can we talk through the process? Because our viewers may not understand the full process for how the state has to call its witnesses first, then the defense. Can you go through that? Give us the 30 seconds on that.
Sure. So the state, they have the burden, so they get to start first on a trial. So they'll usually start out with their witnesses. Once they get done with their witnesses and they believe that they've proven their case beyond a reasonable doubt, they'll go on and rest. At the time that they rest, it then moves to the defense if they want to put on a case. They don't have to put on a case, but if they decide to put on a case, then it's their opportunity. They'll call witnesses. Once they're done putting on and presenting their case, what they'll end up doing is they will rest. And then because the state has the burden, if there's any sort of rebuttal evidence that they would like to do, the state could then put on additional witnesses. And then once you hear those magic words of close and close, it's time for closing argument.
Yeah, I know that some people were probably caught off guard that the state rested today. I kind of anticipated that they were going to, but there was a sidebar with the attorneys. I don't know if you guys caught that. And then the judge told the jury, we're doing court business to kind of move this trial along. So I'm wondering at one point, because I believe that there were more people on their witness list, if the judge said, hey, let's consolidate this and let's keep it moving, or what do you think happened there? Why they rested so soon?
Yeah, well, I think that the judge, I definitely think that the judge is going to let them try their case. So he's not going to try to have any sort of persuasion on what the individuals do. But I think sometimes because once the state rests, the defense has to make or figure out what they're going to do in regards to, are we going to present a case? Are we going to call witnesses? Are we going to call our client? Do we need a moment to talk to our client? So once the state rests, the judge will normally let both sides have a little bit of time to figure out, hey, what's the roadmap going to look like going forward?
So we know there's going to be at least 9 days from the time we start opening statements. So are you back timing in your head, okay, if the state has this much time, the defense may take 1 or 2 days, then it goes to the jury, then we have sentencing after that. So if there's sentencing after that, so are you back timing some of that if you're the defense and the prosecution?
I mean, I think for the most part, you kind of look at it, if the state went and had 3 days of evidence, you normally don't expect the defense to have that many days of evidence or witnesses to put on. And what we've seen them be able to put on 3 witnesses already. And so, and they've moved through on those. So that's in about a couple hour period. So I imagine that, you can kind of start looking at that. The defense may be a day and a half, full day and a half. And then we'll figure out on whether or not they're going to go on and close and go into arguments, or if the state's going to put on a few rebuttal witnesses.
If you're the defense, do you put Carmelo-Anthony on the stand or don't you? Because a lot of what they were being asked in voir dire during jury selection were questions about, you can't hold this against a client if he doesn't take the stand. The defendant the burden's not on him to prove his innocence. But in this case, because he's the only one that can really say, I did this because I was in fear of my life, or I needed to defend myself, would you put him on? Or
well, ultimately it's his decision, but he's going to probably rely on whatever his attorneys are recommending for him. I think on something like this, from a defense attorney standpoint, you have to look at it. We saw kids that were 17 and 18 years old testifying, and it doesn't always go as smooth as you could talk to them 100 times prior, and then they get on the stand, and you just never know what's going to come out. And so sometimes people are great with public speaking, sometimes they're not. You have an adult that knows the law and knows how to ask those questions and everything. You sometimes don't want your client to look one way or the other just for being nervous or not having the answer or having the answer. And so on a case where there's self-defense, if you believe that there's any bit of evidence of self-defense that got brought out by other witnesses, then there might not be a need for you to put your client on, because the smallest amount of evidence requires the judge to put put that in the jury charge.
Today we have some of the most vivid retelling of what may have happened under that tent on April 2nd, right? We are not naming these young witnesses, and Rebecca, can you tell us why we're not naming these witnesses?
Well, they're underage, and obviously there's also been so much publicity on this case, and even though some of them are 18 and are, adults, considered adults, we're not naming them just to protect these witnesses. The judge has been very clear about wanting us to protect their identities simply because there is just so much volatility around this trial on both sides that are very passionate about what's going to happen here, and we wouldn't want to be responsible for anything.
Let's take one of the interactions that one person testified to, and that's they asked Karmelo-Anthony, "Who are you? Why are you here?" And his answer is, "I'm a nobody. Don't worry about me." And that's when there's pressure for him to leave the tent. And his answer, and I can't say a lot of the words because it came with a lot of expletives, but I'm not leaving. And then, curse. There's a lot of curse words that. For the first time, we're actually hearing that they're actually curse words, because some of the other testimony we heard, we didn't hear about any curse words, but now we're hearing some of that.
Yeah, I think that's one of the things, that one witness that said that was one witness that got into the cursing element of it. And, I think as those jurors are looking at what the other witnesses have said, they're going to try to look to see what corroborates. Hey, should I believe all of what this witness says? Should I believe part of what this witness says? Or should I believe none of what this witness says? I think on that one of the hurdles is going to be, he mentions those things, but also later on when the defense cross-examines him, because he also kind of distances himself from knowing Mr. Anthony, and the defense had pictures of Mr. Anthony being with this witness and with his family and things of that sort, times of hanging out and things of that sort. So.
When you're hearing discrepancies between these young witnesses, how do you take that if you're the defense or the prosecution?
I think it's common. I mean, if you have any witness that comes in there and you can put 5 witnesses on and they all have the exact same version to the T, then I think that there's something a little concerning about that. Everyone has a different perception on what happens and what they observed out there. So you expect some things. Now, what the big thing that you're going to look at is if it's something from a big element of what it is. So if it's anything to go with the physicality, who did what first? Well, that's going to be if you have various witnesses saying different people did different things at different times, then I think that's something that you got to measure to see which one you believe is credible, or which part of their testimony is credible. It can be common. That's why they say no matter how many times attorneys talk to witnesses, you never know what's going to come out from the witness stand.
I think one of the biggest things that I took from that witness was when they went through all of the details back and forth, and the questioning. Then they asked him, well, whose fault was it? And he said, I don't know. I mean, if I were the prosecution, I would have been like, oh, wait, because I don't think that they anticipated. And like you said, you can prep somebody, and they may still surprise you with their answer.
Right. Sure. And I think the one thing, because you never know what's going to be said from there, and so you have 2 challenges. It's, do I make a big deal of this and draw attention to it, or do I just kind of let it go because I've got other witnesses that have said something that may be or go against it? Because I think it was very well planned out by Bill Werski, the lead prosecutor on it, and just constantly, I mean, he would say some of the same questions to every witness at the very end, and it would go to the provocation, who provoked it, and was this murder or was this self-defense? And so I think that's the theory that the state's going to constantly try to bang and show, hey, this was unprovoked stabbing, and I think that if you kind of really start panicking whenever one witness says something, then sometimes you just draw attention to that matter.
When it comes to, you and I were talking in the hallway about the defense painting one, not so much painting, but when talking with one witness about who ends up being the agitator. Right? And that question of who was the agitator is probably central to both cases, right?
Yeah, I think it is, because I think the thing is that when you're talking about self-defense, I mean, you have to look at the totality of everything. And so we could see this afternoon, especially as in regards to whenever they're trying to paint a picture of what's going on exactly in that tent. Well, the defense made a big point in regards to talking about the number of people, because of course that's going to be in anyone's mindset. If you've got a tent full of folks, someone's aggressive action may go to you figuring out like, hey, I mean, there are a lot of people that I don't go to school with that are in here. And so I think that's why the defense is painting a picture of what was going on in there. And if you have agitation, or if one of the if Austin was the one that started something or started some of the agitation part of it, then hey, what would my client think? Because there might be other individuals. And so I think that they were trying to hammer that point on how far were people, what was going on. They really pointed out the fact that Mr. Anthony stayed seated the whole time and things. And then even some of the dialogue between them as far as, okay,
Yeah, that's almost a given. I
Yeah.
think we've learned that that's a given now.
That he was seated, yeah.
That he was seated.
Yeah.
And Austin Metcalf was standing up at the time.
Right. Yeah.
Right.
And so I think that's each side's going to try to paint the picture of what it looked like out there. And so the state's going to try to either kind of give space and give time, give reflection time, just give a moment of, hey, that he was acting, he was in the wrong in his actions. And I think the defense is going to say, well, no, he was justified because, yes, it could be a push or it could be a grab, but in the scheme of everything else, if there are other people yelling, or if two people are yelling and there's other individuals and you don't know who those people are, and all of a sudden now it's getting loud and you don't know if this person's going to come from this direction, this person's going to come from this direction. And I think that that's why you're getting everyone trying to paint the picture of exactly what's going on, and why it's important when they're asking these witnesses, where were you?
Yeah.
What did you see?
And they did get several of the witnesses to say that there were several of them that were yelling different things at him. And, I've just noticed covering crime for so many years that witnesses are just going to vary on their accounts. I mean, I've literally read police reports where one witness will say, oh my gosh, the getaway car was white, and the other one will say, no, it was red, and the suspect's very like 5'2", the other one will say it's 6 feet tall. So they're just going to remember different details. And remember, these are all kids that also witness a traumatic event. They've seen their friend get stabbed and die in front of them. And so, you may not remember all the details, and some of them might have blocked out some of the details. So you're just going to hear different things in varying events, even though generally they agreed on what happened.
For the first time, we're hearing from the medical examiner, and I think I was talking to you in the hallway, and you say that's a phase by itself. The medical examiner, that's usually one of the longest pieces of testimony. We're hearing from the medical examiner, Dr. Elizabeth Ventura. We should mention that Bill Werski, with the state, advised the family to leave the courtroom for that because of the sensitive nature of some of the photos.
Yeah.
We ended up not seeing any of those photos. It was just shown to the jury. Can you let's speak to the medical examiner.
Yeah, I think that was a good move. I mean, anytime you have these cases, autopsy photos aren't fun to look at.
Yeah.
I've sat there and had to look at plenty of them. And so just giving family members both, and people from both sides of the family decided to get up and walk out a little bit, because it's just a very sensitive nature. You have autopsy and you've got some photos of what things look like as things were as they were pulling out things and looking at things and looking at the wounds and things.
And I've noticed in the last several trials that I've covered that they've only shown the autopsy photos to the jury, kind of old school. Instead of publishing them on the screen, they are showing them to them individually, or even passing them out in the jury box to avoid some of that. So the gallery didn't actually see the autopsy photos, just the jury. And those are the people that need to see the pictures, because they're the ones that are going to decide the fate.
And the judge only allowed 4 photos in. The state they said, look, I went
They
to
challenged
the medical
2 of them.
Exactly.
Challenged 2 of them. Those were denied.
Right.
Yeah.
So only 4 out of several came in, and that's whenever you hear them talking about 403. It's to make sure that nothing is overly prejudicial. Like, is this the bare minimum of what you need to explain the stab wound and things?
So Toby Shook had a demonstration that happened right in the middle of the courtroom with Dr. Ventura. And Toby Shook asks the question and demonstrates just about every possible scenario where the knife could have entered his body. Right. Why is that important for the defense, you think?
I think on Toby's point, the points that I think he was making is, one, The medical examiner testified that the full blade was not in, like the
was
depth of
it was
it.
2 inches deep.
Exactly, and I
Because
think
that's what
the
was
knife.
folded. The knife was
Right.
folded when they found it.
Right.
Yeah.
Yeah. And so I think Toby wanted to point that out to show, this wasn't some big forceful or an attack type.
Yeah.
I think that's what he's going to say, that it's not like the blade was forced in there. And I think also from the standpoint of the angle of the cut, I think that they wanted to show, okay, so does this corroborate if he's sitting down? Is this a possibility if Austin is above him or standing in front of him, above him? Would that also be an example of what would happen if he's getting pushed back and that blade goes up? Is it possible that angle could be cut? So you could hear the prosecutor and the defense attorneys going back and forth on some of the hypotheticals. So they won't get in the weeds of that, but they're trying to show from a standpoint, hey, this could be consistent with exactly what you've heard from the defense side, but it could also be consistent from what you hear from the state.
And, Bill Werski on the cross with Dr. Ventura essentially says there are dangers with doing these kinds of reenactments.
Right.
And why is that?
Yeah, well, I think it's because there's so many hypotheticals and situations and circumstances, and just like the medical examiner said, it's a body in motion. So anytime you have two individuals potentially in motion, there could be all sorts of possibilities in regards to that. So I think each of those sides probably feel good at what the medical examiner said to help them move their ball forward to some extent.
I want to go back to the friend who testified.
Yeah.
I thought it was very interesting that the defense did make a point of saying you had your phone, and so he brings the phone up like he says he's going to pretend like he's recording the incident, but then there's no video when the police look at it, and he's like, oh, well, I didn't really record. I thought it was funny that they were going to argue. I was just being dumb.
Yeah.
And I thought the defense bringing that up kind of sort of raised the question, like, why wasn't there video? Like, all these kids have phones, and no one actually, videotaped
Bill
anything
Werski
that
actually
happened.
mentioned that.
Yeah.
We wouldn't have to. This wouldn't be a problem if we actually had footage of what's happening.
And I think the defense will probably come back and circle back on that and possibly say, you knew things were getting heated and you knew things might go off, and this is one of the individuals that I believe they're going to say was closer to Austin than he was to Mr. Anthony. So I think that they're going to say the fact that you're pulling your phone out, you tend to believe something may happen based on what you're either hearing or seeing.
And they asked him, why didn't you step in and defuse it? Why didn't you've been to barbecues with him, he had pictures with his grandmother,
Right.
Why didn't he say, hey, that's my friend, or I know him? Because they're asking, well, who are you? And that was one of the questions the defense asked that witness.
It was an opportunity for him to diffuse this entire situation.
Why didn't you say, well, that's my friend, y'all leave him alone, and didn't say anything. Instead, he took out his phone.
And his answer was, I was talking to another friend, and I had kind of lost contact with this conversation. Right. And that, I don't know if that's going to fly for a lot of people, because now it's ended in the death of Austin.
Well, and the defense also brought in those photographs that show that several times outside of this event, he had been around Mr. Anthony and things of that sort.
Okay, so the state rests. Now we go to the defense. You made a comment. Make their witnesses your witnesses, right? So we hear from the Centennial coach, and we talk about track culture versus football culture.
Right.
In track culture, it's sort of kind of loose, and you can kind of just mosey around and be around at the event. Why is that being brought up?
Yeah, because he's saying football culture, because this coach football, coach track. Football culture, it's warrior, it's us versus them. Track culture is more, since it's an all-day deal, to show that, hey, it's not uncommon for individuals to be in each other's tents. They know because they've gone to school or they've competed against each other, or some of them went to middle school and now they're at separate high schools. And so I think just to show that that's a common thing in regards to that, and the state cross-examined him to say, hey, so the Austin was acting, if they have a rule that they don't want individuals in their tent, then, and the coach isn't there, then sometimes they will appoint some of the students or some of those athletes to do that. So I think that's why that was very important. And and you said, yes, as a defense attorney or a prosecutor, you want to make their witnesses your witnesses. And it might not be on every issue. You find out what that 1 or 2 points that you need to make with that witness. And I think when it came back around for Bill I think the defense definitely got out some of their things, that this is common, this is normal, talking about how he had been a captain at one point, Mr. Anthony, and things of that sort. But then also that he was gone around this area, and I think that the state ended up showing, well, is that common for if a coach is gone, for them to sometimes designate
a player,
player to kind of enforce the rules of what that is.
Yeah, and if you remember, they said that there was a text message that they sent to Austin Metcalf, his coach, saying you need to step up and be a leader today. So he was anticipated to be the leader that day, even though the other Centennial says, well, we are required to have a coach there because they're teenagers. But he also said we didn't have a tent that day when it was raining because we didn't have the manpower, and the tent might have been coming. It just didn't get there in time.
Let's go through. So we don't have any cameras inside the courtroom, but we do have an awesome sketch artist by the name of Pat Lopez, who's been taking sketches. So let's describe this one. This is with one of our minors, and this is the one who's claims to be a friend, claims to not be a friend, but is probably closer to Carmelo-Anthony than he's probably letting on.
Yeah, I thought that was a very key witness for the defense. But just like you said, you make your witness, their witness, your witness. I think that the defense also kind of did that with the prosecution's witness, with this witness, because they made him admit that he was actually closer. Because when they initially asked him, well, did you know him? He's like, well, I kind of knew him, but not really. He's not my friend.
Yeah. I knew him through his ex-girlfriend.
Yeah, and then you see all these pictures where he's invited him to places. And to play
Let's talk about this next photo. This is with Dr. Ventura. What's happening here?
That's that's the autopsy photos where he only published to the jury just out of respect to the audience and everything, and that was him and the medical examiner walking through and her describing her findings.
We have just a couple minutes left. Rebecca, there's a high-profile person who is not in the courtroom, and you think that person could be called. Who's that?
Hunter Metcalf, the twin brother, I expected would be the last witness for the prosecution. I suspect because he's not been in the court, because he's there's called the rule, and they're not allowed to listen to other witnesses' testimony. And so I suspect that they're going to bring him back as a rebuttal witness, and that will be how the state ends, and it'll be the last thing the jury hears is his brother.
The strategy there.
Yeah, I think you want to leave them with some sort of emotion, filling your case and stuff. And look, I've got a twin brother, so I could only imagine if I had to get in there. I'm telling you, I'd be tearing up as well. I mean, that's a bond. It's a very particular bond, and so the thing is I could see them wanting to leave or end on a high note for them.
Kevin, I want to thank you for joining us here. Rebecca, we'll see you again on Monday when the defense continues some of its witnesses. After this episode, you'll be watching more of the content that we've put together for this incident, so you can sort of get up to speed on what's happened here. You're watching Day 5 of After the Trial.